us a lot about the commitment of the Secretary and of his government to the promotion of the harmonization of international trade law. And it also reflects very much the relevance of international legal standards for an economy and a society such as Hong Kong. He is also, if I may say so, a remarkable interpreter of the principles of the rule of law and of separation of powers. It is not often we see such relentless commitment to those principles. We had the opportunity in the last 2 days to be well exposed to the judiciary, recognizing, of course, the unique and fundamental role of the judiciary to support a successful implementation of alternative dispute resolution systems, and in particular, of course, of mediation. I learned from Mr. Yuen sometime, one of your recent speeches, that you said that the cultivation of mediation culture takes time. And I think we also heard a lot of that in the last few days. There was, underlying all the discussions, a thread of the importance of legitimacy and the recognition of that legitimacy. In that sense, the Planning Committee felt that we would, of course, benefit from having a governmental view, being governments and policy makers in any of its forms or densities, carriers of the delegation of legitimacy by the people, and being the primary executor of that mandate. So beyond all the technicalities that we discussed, that we so brightly and lively have been discussing, we must never forget that access to justice and promotion of the rule of law should be the driving forces of all of our work, practitioners, judiciary, governments, and international organizations. So today we'll have the view of the role of mediation from the perspective of one of the key policy makers in the region. And it is indeed a view from someone that knows about it. Mr. Rimsky-Yuen was a barrister in private practice, specializing in commercial disputes, and he serves as an arbitrator and a mediator in commercial disputes. So as Secretary for Justice, he's also the chairman of the Advisory Committee on Promotion of Arbitration and the Steering Committee on Mediation. So I believe I can say on behalf of the Planning Committee, and I dare to say on behalf of all of us, how honored we are to have you with us, Mr. Secretary, and you have the floor. Thank you very much.
Distinguished guests, ladies and gentlemen, good morning. First of all, may I express my gratitude for inviting me to this Asia-Pacific International Mediation Summit, and also for giving me this opportunity to address such a distinguished audience. The Asia-Pacific region is a region of diversity. Different jurisdictions have different legal history, different legal culture, and different historical background. However, mediation knows no boundary and is a form of dispute resolution which can overcome the challenges of different legal systems. I have no doubt that different jurisdictions can join hands to build a better foundation and a common platform for the future sustainable development of mediation. With this in mind, the topic I have chosen for this morning is developing mediation, sharing the Hong Kong Special Administrative Region experience. I intend to share with you the experience of Hong Kong in developing and promoting mediation as a means of dispute resolution. By so doing, if I may stress, I have no intention to suggest that the Hong Kong model is necessarily the correct model, still less the only correct model. Far from it. It is plain that each jurisdiction will have to search its own path. My intention is to offer our experience so as to hopefully trigger more exchange of experience among jurisdictions interested to develop and promote mediation. Mediation as a means of dispute resolution has been used in Hong Kong for a considerable period of time. especially in the context of family disputes and construction disputes. However, admittedly, the developments that have made mediation an integral part of dispute resolution landscape only took place in the past decade, and especially after 2007. In less than a decade, not only has mediation become much more popular than before, it has since developed into a form of deeply rooted dispute resolution culture in different sectors of the Hong Kong community. This development, as I see it, is the result of the combination of various factors, including, first, government policy; second, an appropriate legislative framework; third, strong institutional support; fourth, joint efforts of the legal and dispute resolution communities; fifth, extensive promotion and publicity efforts. Let me start with government policy. For years, by capitalizing on its strong common law tradition and modern legal infrastructure, the Hong Kong government has been consolidating and promoting Hong Kong as a center for international legal and dispute resolution services in the Asia-Pacific region. As far as mediation is concerned, this objective was first formally announced in the 2007 policy address. For those who may not be familiar with the situation in Hong Kong, policy address is the government policy paper of the highest level published on an annual basis. To demonstrate our continuous commitment, this policy objective was reiterated in even clearer terms in the 2014 and 2015 policy addresses. You may ask why the Hong Kong government places great importance on dispute resolution, including mediation. We believe there are at least three good reasons. The first reason concerns the rule of law and access to justice. Lord Bingham, in his well-known book, The Rule of Law, identified 8 elements when explaining the concept of the rule of law. One of the elements is dispute resolution. According to Lord Bingham, means must be provided for resolving without prohibitive cause or inordinate delay bona fide civil disputes which the parties themselves are unable to resolve. Traditionally, access to justice was equated with access to court. However, as the concept of civil justice evolves, this is no longer the case. As the Chief Justice of our Court of Final Appeal observed in another mediation conference, the administration of justice includes an integral activity, the resolution of disputes to arrive at a just, proper, and legally justifiable result. Mediation fits into this rubric. In this regard, it may also be pertinent to note that access to justice has been defined broadly by the European Union to include not only access to court, but also access to out-of-court or extrajudicial dispute resolution. Second, we believe dispute resolution has a close relationship with economic development, which is of crucial importance to Hong Kong as an international financial center. The effective dispute resolution regime plays a significant role in protecting private properties and enhancing confidence in commercial activities, which in turn promotes economic development. The third reason is a sociological one. A fair, just, and cost-effective dispute resolution regime is vital in maintaining social harmony. It enables citizens to have their disputes resolved through proper channels so that their grievances can be properly addressed and differences effectively resolved. To take forward the government policy of promoting mediation, the Department of Justice has established various cross-sectors committees at different stages to work on the relevant topics. The first one is the Working Group on Mediation, which was established in 2007. It published its report in February 2010, setting out 48 recommendations covering three important areas, namely regulatory framework, accreditation and training, as well as publicity and promotion. One of the key recommendations was the need to enact a mediation legislation, which I will deal with later. The second one is the Mediation Task Force, which was established in late 2010 and which was tasked to implement the numerous recommendations made by the working group. This task force completed its task by late 2012 and was replaced by the Steering Committee on Mediation, which is the current committee assisting the Hong Kong government in the promotion and development of mediation. Mediation cannot be conducted in a legal vacuum. Some jurisdictions have specific legislations governing the conduct of mediations, and some do not. In the case of Hong Kong, the Mediation Ordinance was enacted in June 2012 and came into effect on 1st January 2013, following the recommendation of the Working Group on Mediation. Apart from taking heed of the international trend, illustrated, for instance, by the EU Directive 2008/52 and the UNCITRAL Model Law on International Commercial Conciliation, we take the view that the enactment of the Mediation Ordinance can remove uncertainty, enhance clarity, and promote accessibility. In particular, the ordinance removes any uncertainty created by case law over the extent of confidentiality, which we believe is the cornerstone of mediation. In this regard, Section 8 of the Mediation Ordinance sets out the fundamental principle that a person must not disclose mediation communications, followed by a list of the exempted situations where mediation communications may be disclosed. In addition, Section 9 stipulates that mediation communications may be admitted in evidence in any proceedings, including judicial, arbitral, administrative, or disciplinary proceedings, only with leave of the court or the tribunal pursuant to the requirements set out in Section 10. Besides, by stating the legal position concerning the key issues relevant to mediation, the ordinance enables mediation practitioners and end users to have a quick understanding of the legal position in a clear and accessible manner, and thereby obviates the need of having to plow through the case law. This advantage is not without significance, since not every mediation practitioner or end users has legal training. In short, the Mediation Ordinance encourages the use of mediation by ensuring confidentiality, while at the same time preserves the flexibility of the mediation process. Government efforts alone would not be sufficient to promote or maintain a sustainable development of mediation. Supports from other sources are definitely necessary. As in the case of some other common law jurisdictions, civil justice reform and the support of our independent judiciary provide additional impetus to the development of mediation in Hong Kong. One of the most important impetus, perhaps, is the Hong Kong judiciary's introduction of Practice Direction 31. This, we call PD 31, was introduced as part of the civil justice reform and came into effect on 1st of January 2010. With the exception of certain specified legal proceedings, PD 31 applies to all civil proceedings in the court of first instance and the district court, which are begun by writ. Under PD 31, all litigants of the relevant legal proceedings are required to make genuine attempts to settle their disputes through mediation. Failure to mediate without a reasonable explanation may attract adverse cause consequences. Besides, the Hong Kong judiciary has promulgated other practice directions for specific proceedings, including personal injury claims, building management claims, probate and related disputes, as well as shareholders' disputes, which contain similar requirements. In addition to practice directions the Hong Kong judiciary has set up a mediation information office within the High Court building with a will to assisting litigants to make the best use of mediation in resolving their disputes. Further, mediation coordinators' office have been set up in the family court and the lands tribunal so that appropriate assistance can be provided. Another form of support which is also of crucial importance is the provision of legal aid for mediation. In this regard, the legal aid department has been very supportive. Initially, legal aid was only made available in matrimonial cases. Since 2009, legal aid has been extended to all forms of civil proceedings covered by our legal aid scheme. The financial aids so provide cover mediators' fees and related expenses incurred by the legally aided persons undergoing mediation in the course of the aided proceedings. By way of example, in the year 2014 alone, legal aid for mediation was granted in a total of 974 cases, out of which 148 were matrimonial disputes. The statistics provided by the Legal Aid Department show that from April 2009 to December 2014, of the legally aided cases that proceeded to mediation, about 58% of them result in settlement. Hence, the availability of legal aid for conducting mediation in legally aided proceeding has greatly facilitated the satisfactory disposal of those legally aided cases. Support from the financial sector is also worth noting. In October 2008, 1 month after the collapse of Lehman Brothers, the Hong Kong Monetary Authority appointed the Hong Kong International Arbitration Center to administer an investment products dispute resolution, mediation, and arbitration scheme to resolve the Lehman Brothers related mini-bond claims between banks and small investors. The success of this scheme has eventually led to the establishment of the Financial Dispute Resolution Center, the FDRC, in November 2011, jointly by the Hong Kong Monetary Authority and the Securities and Futures Commissions of Hong Kong. The FDRC is a non-profit making company limited by guarantee and is responsible for administering an independent financial dispute resolution scheme to resolve financial disputes between individual customers and financial institutions by adopting the approach of what they call mediation first, arbitration next. The quality, competence, professional ethics, and integrity of mediators are crucial in inspiring public confidence in the use of mediation as a means of dispute resolution. Further, to ensure that mediation will enjoy a sustainable development, the proper training of mediators is equally important. One of the challenges faced by Hong Kong, as is perhaps also faced by other jurisdictions, is how to maintain professional standards on the one hand, and at the same time guard against over-regulation, which may have the effect of stifling the healthy development of mediation. We believe mediation should be best promoted as a multidisciplinary art of dispute resolution, and hence the practice of mediation should not be confined to the legal profession. Instead, non-legal professions should be encouraged to join the mediation circle. At the end, Hong Kong chose self-regulation. This is the reason why the mediation ordinance I mentioned earlier does not contain any provisions which deal with the qualification or accreditation of mediators, but instead contains a section aimed to encourage non-lawyers to practice mediation. Following the recommendations of the Working Group on Mediation, the Hong Kong Mediation Accreditation Association Limited, we call it the Hong Kong MAO, was incorporated on 2nd of April 2013. It is a non-statutory industry-led body tasked to deal with the issues of accreditation, training standards, and disciplinary matters concerning mediators. It has 11 corporate members, including the 4 founding members, namely the Bar Association, the Law Society, the Hong Kong International Arbitration Center, and the Hong Kong Mediation Center. These bodies are the major stakeholders, and their members are closely involved in the development and promotion of mediation in Hong Kong. As at January 2015, Hong Kong MAO has over 2,100 accredited mediators and is now the largest single accreditation body for mediators in Hong Kong. To avoid conflict of interest, Hong Kong MAO itself does not offer training courses. The mediators accredited by Hong Kong MAO have a very diverse background and come from different disciplines and professions, including legal, accountancy, architecture, medical, social work, just to name a few. The aim is to ensure that there will be a reasonably sufficient pool of skilled mediators with specialized knowledge and experience to cater for mediations involving different types of disputes. Since its commencement of cooperation in April 2013, Hong Kong MAO has put in place policies and standards concerning grandparenting and accreditation. It has also formulated standards of mediation training and devised a set of disciplinary procedure for addressing complaints against mediators. In short, Hong Kong MAO is heading towards the direction of becoming the premier mediation accreditation body of Hong Kong, which is the very aim of its incorporation. Apart from Hong Kong MAO, another non-profit making organization worth mentioning is the Joint Mediation Helpline Office, jointly established in 2010 by 8 professional bodies, namely the Bar Association, the Law Society, the Hong Kong Mediation Council, the Hong Kong Mediation Center, the Chartered Institute of Arbitrators, East Asia Branch, the Hong Kong Institute of Arbitrators, the Hong Kong Institute of Architects, and the Hong Kong Institute of Surveyors. Working closely with the Mediation Information Office set up by the judiciary, but independently, this Joint Mediation Helpline Office provides assistance to parties, especially parties who are not legally represented, who seek to settle disputes via mediation. To cultivate a mediation culture so that people from different sectors of the community are willing and prepared to resolve disputes by mediation, publicity and promotion are indispensable. This task of publicity and promotion is handled by the Public Education and Publicity Subcommittee, one of the 3 subcommittees established under the Steering Committee on Mediation. Seminars and talks are held from time to time, catering for the different interests of different target groups. Examples include the Mediation Week held in March last year, which comprised a 2-day conference with 46 local and overseas leading speakers, including Lord Wolf. This conference alone attracted over 1,000 participants from different sectors of the community. In addition, the Mediation Week offered 18 other seminars and workshops devised for different specific sectors. There were also 24 mediation talks delivered to primary and secondary school students so that the younger generation can have a taste of mediation at an early stage, and so that peer mediation can be better promoted. Apart from focusing on training to people in the community, the Hong Kong government does not neglect training for its own civil servants. The Department of Justice has been organizing seminars and training its own legal counsel, as well as for non-legal civil servants who may have to be involved in mediation. So far, over 1,000 civil servants without legal background have been trained in mediation so as to ensure that mediation culture can also be spread within the government. So far, I have been dealing with what have happened in the past, let me move on to briefly deal with the future, since the promotion and development of mediation is a continuous process. In short, the Department of Justice, with the help of the Steering Committee on Mediation and other stakeholders, are working on various initiatives to ensure a sustainable and healthy development of mediation in Hong Kong. One of the key initiatives is the study on the need to introduce an apology legislation in Hong Kong. As in some other common law jurisdictions, the making of an apology may well have legal implications, as it may be perceived to constitute an admission of liability. This legal concern often prevents parties to a dispute to offer an apology, even though we know full well that sometimes an apology at an appropriate time may be highly conducive to the striking of a settlement, especially in cases where monetary compensation is not the key consideration. With a will to doing away such legal concerns so as to enhance the possibility of settlement, the Regulatory Framework Subcommittee of the Steering Committee on Mediation has been tasked to look into the desirability and viability of introducing an apology legislation in Hong Kong. The work has been progressing constructively, and we expect the report will be released in the near future. Another initiative we are working on concerns the specialization of mediation with reference to specific types of disputes. One of the areas we are working on is the use of mediation to resolve intellectual property disputes. On top of facilitative mediation, we are exploring the use of evaluative mediation to resolve intellectual disputes, including licensing disputes, since Hong Kong is a key intellectual property trading hub in the Asia-Pacific region. In this regard, I anticipate further announcement will be made in the next few months, followed by activities for attaining these objectives. The third area we will be looking into is the relationship between mediation and other forms of dispute resolution. Whilst we may not fully subscribe to Professor Frank Sanders' concept of the multi-door courtroom, we do see the desirability of strategically planning the future development of mediation against the bigger picture of dispute resolution. To this end, we believe there is both desirability and room to develop an appropriate relationship between mediation and other forms of dispute resolution, such as arbitration and expert determination. As the law in Hong Kong now stands, we already have sections 32 and 33 of our arbitration ordinance dealing with MET-ARB or ARB-MET. We believe similar marriage between mediation and other forms of dispute resolution can be further explored. Ladies and gentlemen, I'm glad that mediation is flourishing and booming in the Asia-Pacific region. May I conclude by making this remark. I firmly believe that jurisdictions within and beyond the Asia-Pacific region do not need to perceive each other as competitors, still less as rivals. Instead, we each have our strength, and we can be perfect partners in the future development of mediation. Hong Kong stands ready to cooperate with other jurisdictions in taking the development of mediation to a new height, and we welcome further exchanges and dialogues on how there can be better cooperation among jurisdictions within the region and beyond. I hope to see you all in Hong Kong, either making use of our mediation services or sharing with us your experience. Thank you very much.